For South Surrey, White Rock.
Thank you, Mr. Speaker. Like some others in this House, like my colleague who was just speaking, I am a lawyer, and the practice of law has been a large part of my life. My son and two of my daughters have followed me into the legal profession, and that is a source of pride to me as they pursue their professional careers. I continue to be grateful to have been appointed to Queen's Counsel some 23 years ago now, and to have been elected the president of the BC branch of the Canadian Bar Association the year previous. I have a deep appreciation and passion for the law and its unbiased application. In the plainest of terms, Bill C-9 amends the Judges Act to replace the process through which the conduct of federally appointed judges are reviewed by the Canadian Judicial Council. It establishes a new streamlined process for reviewing allegations of misconduct that don't reach the threshold for a judge's removal from office, and the process by which recommendations regarding removal from office can be made to the Minister of Justice. These provisions also apply to persons other than judges who are appointed under an Act of Parliament to hold office during good behaviour. This bill was previously tabled in the Senate as Bill S-5 on May 25, 2021. The legislation before us is the result of consultations conducted by the federal government in 2016 on reforming this process. That's 6 years ago, Mr. Speaker. It is incredibly important that the judicial system be just and fair, holding accountable those who are both behind or in front of the bench. Increasing public confidence in the judicial system while ensuring the independence of the judiciary is necessary for the foundations of our justice system to continue to function as intended. Many will recall that in response to comments from Justice Robin Camp at a sexual assault trial in 2014, former interim Conservative leader Rona Ambrose introduced a bill to require seminars on sexual assault to be taken by federally appointed justices. At the time, the Alberta Court of Appeal panel ruled that Justice Camp seemed to not understand laws on consent and an alleged rape victim's sexual activity, and that his acquittal of the man may have been colored by, quote, sexual stereotypes and stereotypical myths which have long since been discredited, end quote. Justice Camp's ruling was thrown out and a new trial date set. Justice Camp went on to resign from the bench in 2017 after the Canadian Judicial Council ruled he should be removed from office. Before this case, there were volumes of case law and newspaper columns about jurists who misapprehended sexual consent or post-assault behavior, who then went on to preside in court and rule again on other such cases. An earlier version of that bill later received royal assent on May 6, 2021. This bill can be viewed as an attempt to increase confidence in the judicial system, shaken by the words and actions of Justice Camp and others. Victims' rights being fairly represented are an integral aspect to the proper functioning of the judicial system. One important aspect of the court process is the submission of victim impact statements, which are written statements from a victim or victims that describe the physical or emotional harm, property damage, or economic loss which the victim of an offense has suffered. Our courts take these statements into account when an offender is sentenced. This gives victims of crime a voice in the criminal justice system. This government has not been prioritizing victims' rights, and they are failing Canadians and the integrity of our judicial system as a result. Inexcusably, the role of the Federal Ombudsman for Victims of Crime has been vacant since October 1st, 2021, with the Justice Minister's office saying it will be filled, quote, in due course, end quote. The Ombudsperson has a critical role in highlighting and reviewing systemic issues that negatively affect victims and emerging issues. This vacancy is simply unacceptable and sends a message to survivors and Canadians alike that they will not necessarily be represented fairly in the justice system. Adding to concerns victims of crime are not being heard is Parliament's failure to complete a review of the Canadian Victims' Bill of Rights, The review was supposed to happen in 2020. Canadians' perspective of the judicial system reflects in part these failures. According to the Justice Canada studies, regardless of whether their cases did or did not go to trial, participants were asked to rate their level of confidence in the police, the court process, and the criminal justice system in general. Few stated that they were very confident. Indeed, approximately 2/3 of the responses stated that they were not confident in the administration of justice in general. This data is not coincidental. It is imperative that our judiciary system continues to adapt to effectively represent Canadians fairly. A Department of Justice report stated that, quote, for the 2016-17 fiscal year, 42% of all sexual assault case decisions, levels 1, 2, and 3, in adult criminal court resulted in a finding of guilt. 42%. And yet, according to StatsCan, statistical evidence has classified 14% of incidents of level 1 sexual assault as unfounded in 2017. In comparison, the more serious levels of sexual and physical assault were classified as unfounded in only 9% of level 3 sexual assaults, 7% of level 2, 3% of level 2 physical assaults, and 1% of level 3 physical assaults. Why the difference? This bill modifies the existing judicial review process and allows for sanctions such as counseling, continuing education, and reprimands. Improvements in the administration of justice will result. The bill states the reasons a judge could be removed from office, including infirmity, misconduct, failure in the due execution of judicial office, and that the, quote, judge is in a position that a reasonable, fair-minded, and informed observer would consider to be incompatible with the due execution of judicial office, end quote. In the case of a complaint that alleges sexual harassment or discrimination, it will not be dismissed. The full screening criteria will be published by the Canadian Judicial Council. The Minister and Attorney General may request that the Canadian Judicial Council establish a full hearing panel to determine whether the removal from the office of a Superior Court is justified. The Council will submit a report within 3 months after the end of each calendar year with respect to the number of claims received and actions taken. This is a prudent measure that ensures transparency and accountability from a senior group of jurists exercising quasi-constitutional duties. Such provisions in this bill enhance and strengthen the Canadian legal system as a whole. As a former parliamentary secretary to the Minister of Justice, I welcome this legislation. Bill C-9 is a move in the right direction. It is not the end of the journey, Mr. Speaker, but the start of a journey. Thank you.